Okay, let us
Hi. We have been inviting experts in various domains to discuss and debate and also answer questions from the audience on various topics, primarily related to best practices in higher educational institutions. But today, the digital technology has become part of our lives, especially the information and communication technology is extensively used, not just only in the universities and colleges, but in the governments. The impact of using ICT is clearly seen in terms of improved services that the citizens of our country get without any intermediaries, with a lot of efficiency, transparency. And we have also seen that the broadband internet usage also is growing up in our country. Today, we have more than 800 million broadband internet subscribers, and the numbers are growing. Perhaps in the recent past, during last 30 years or so, if there is one technology which has significantly impacted the way we live, the way we interact with each other, that's the internet. And the information flow that happens through this backbone of internet is enormous. And we have also seen that newer ways of communicating with each other are evolving as the technology matures. And in the recent past, we have these OTT platforms, and we also have these social media platforms, which has democratized, which has provided greater access for anybody to express their views and to connect with each other. But however, some of these technologies which are influencing our lives, they also need to be governed well. It should not be a platform that nobody owns or nobody really governs it. Then we have seen in the recent past how social media can be used for purposes for which it is not really intended. And similarly, we don't know how safe it is to browse through things on internet. How safe is it for kids, for example, the type of content that appears in OTT. So therefore, there has to be some kind of rules and regulations which will make sure that when we are using this information and communication technology, it is accountable, it is responsible, it is safe to all of us. And keeping that in mind, recently in our country, we have come up with the information technology rules. There is a lot of debate that is happening across the country on the pros and cons of having such information technology rules, because we also have issues related to privacy and freedom of expression. So how do you draw a kind of line between freedom of expression and the privacy issues? And at the same time, how do we effectively use the information and communication technology for the betterment of our society? So therefore, we need to address the issues that arise out of having any kind of rules and regulations, and then come up with a set of rules and regulations which are optimal in terms of meeting the conflicting requirements that we have whenever we use new technologies in our life. Today, we have two speakers to talk to us on these two issues. The first speaker is Sri Vakul Sharma. He is a practicing lawyer in Supreme Court and in various high courts. He has enormous experience looking at the information technology and the related laws and practice. And he will be talking about how the information technology rules that we are bringing out will lead to open, safe, and trusted and accountable internet. Then we have this second speaker, Mrs. Gauri Gokhale, a practicing lawyer over 30 years, and she leads the IP, technology, media and entertainment, and data protection law and related areas. She is also a registered patent and trademark attorney, and we are very glad that she is here to speak to us on the rules and regulations of online curated content on OTT platforms. Both the lectures are very important in the present context. Each speaker will speak for about 20 minutes. And at the end of 40 minutes, we will also have a brief question-answer session, and our experts will answer your questions. So with those comments, I request the first speaker to please deliver the lecture.
Thank you very much. It's my privilege to be part of this particular platform. And my work is just to demystify the information technology rules, which came into existence in 2021 with approximately 20 slides, which I shall be sharing with you. I shall be looking from a point of view of what is or what these rules are meant to be, what are the do's and don'ts to be followed, and accordingly, I believe that we are going to look from a point of view of what is a legal perspective. So I will start with the first slide, the information technology rules towards open, safe, and trusted and accountable internet. Just to make it very sure, the rules are meant for intermediaries. The question is, who are intermediaries? Intermediaries are nothing but a kind of facilitators which are joining the originator, the creators of the content, and the addressee, the recipient of the content on an internet highway. If I have to look from this particular perspective, then I am looking from a point of view of a division of these intermediaries into an information carrier, like Airtel, BSNL, information publisher, like Facebook, Twitter, and information sellers like Amazon and Flipkart. So this is a kind of a mix, a motley mix of what the intermediaries are. I should be honest here when I'm talking about intermediaries, because this particular category is changing its shape. It's changing its ecosystem on everyday basis. Newer and newer models are appearing on the horizon. But let us look into, from the point of view, what the rules are meant to be. Can I have the next slide, please? In a simplistic manner, Section 21W of the Information Technology Act defines what is an intermediary. If we just look into the highlighted version of it, any person on behalf of another person receives, stores, or transmits and record any service, that means that person is an intermediary. So that covers the entire gamut of the intermediary service providers. So these rules are meant for these intermediary service providers. Can we have the next slide, please? If I'm looking into information technology intermediary guidelines, they came into existence on 25th February 2021. And in fact, these guidelines are meant from the point of view of creating due diligence. Creating due diligence means the intermediaries have to create a due diligence in terms of certain legal obligations. These intermediaries include social media platforms. It includes significant social media platforms having a user subscriber base of 5 million and more. That means we are looking into the entire gamut of services being provided on the internet. There have been a amendment to these existing rules in the formation of a grievance appellate committee. I shall be looking into these things a little later. So what I am going to put across to you is that we have got a legal system that governs the internet, in a very trusted, open, and in an accountable manner. Can we have the next slide, please? Can we have the next? Yes. So why these rules? What was the need to have such kind of rules? With the passage of time, the internet became a huge repository of information and information highway. There have been growing concern about the safety and security of women, children, and the kind of a response that was expected from the intermediaries were not forthcoming. We had fake mails, fake profiles, hate mails, hate content. So everyone was feeling as if the internet has gone berserk. So on these issues, there have been various pronouncements by the various courts, including the Supreme Court of India, in various petitions that came before the Supreme Court and other high courts about issues related to fake or hate messages, the viral messages leading to riots, mob lynching, and other heinous crimes. So in order to put across some kind of a decorum, such rules were thought to be part of the legal landscape. Can we have the next slide, please? Can we have the next slide? Why these rules have become so important? Apart from our generic definition of what is an intermediary, now these rules have taken a leap of faith and define what is social media intermediary. A social media intermediary, Facebook, WhatsApp, Twitter, and in fact, any interactive website where you are posting photographs, images, any kind of apps which are being there to create and share knowledge. Such kind of platforms are being defined as a social media intermediaries. And within this classification, we have a significant social media intermediary, that is SSMI, if their registered user base exceeds 5 million or more. So the rules cover the entire range of intermediaries, including social media intermediaries and all such mobile apps as well. Can we have the next slide, please? So what we are looking into? Primarily, we are looking into, and this is what the law says, a due diligence. That is, a basic due diligence has to be performed by all intermediaries. And if you fall in the category of significant social media intermediary, then we are looking into, there are certain additional due diligence that you have to perform. And if you are an intermediary publishing news and current affairs content, then yes, you have to follow certain do's and don'ts as a part of legal obligations. So the point is, what is a due diligence? The due diligence is the very basic do's and don'ts in a form of legal obligations to be performed if you are having or providing any such services. This is what we are looking into. Can we have the next slide, please? The beauty of these rules is to provide a safety to the users like you and I, women and children, because there have been hundreds of incidents of breach of bodily privacy, impersonation, morphed imagery, and we are also looking into content that is obscene and a content that can be classified as a revenge porn. So the idea is to prevent harm and emotional distress. So I believe that the underlying feature of the rules is to provide increased user safety. And this is what the Supreme Court has also said in its various judgments, that a user safety is paramount. Yes, we are looking into the privacy, we are looking into the freedom of expression and speech, but the user safety cannot be compromised. Can we have the next slide, please? When it comes to the messages getting viral and causing community distress, the idea is to identify the first originator of such message. Because the first originator is the originator of a content, and that content has become viral because the nature of the content, because of the hate that it has spreaded. It is just like a wildfire. Wildfire multiplied n times. This is the reach of internet these days. So the idea is to identify that person. And I believe that is the most important element of these intermediary rules, because a lot of content which amounts to a child sexual abuse material, obscene material, and other kind of hate content, fake messages, impersonation, fake videos, deep fake videos. The idea is to identify the person who has started this particular cycle. Can we have the next slide, please? Another important element which I would like to flag is grievance redressal. If as a user, I have a grievance regarding any content about me, against me, available on a particular platform, where should I go? The rule says every intermediary has to appoint a grievance officer, his name to be published, and his contact details, and the grievance redressal mechanism has to be provided. And if you are a significant social media intermediaries, that means you have a large number of user base, 5 million or exceeding that, then that grievance officer has to be resident in India. This is what we are looking into, a kind of a system of proper governance. And the governance begins at the social media platform level. And the best part of this grievance mechanism is that everything is time bound. The grievance officer has to provide an answer within 24 hours of posting any kind of a grievance. And the grievance officer has 15 days to decide the fate of my request of removal of any such content or a hate message. Can we have the next slide, please? This is a kind of a timeline I would request each one of you who has joined this platform to please make a note of this. The grievance redressal, that is 24 hours for acknowledgement and 15 days for disposal. And if there is a content related to sexual extortion, non-consensual porn, then that has to be removed within 24 hours. And if I'm also looking from the point of view that if there is a court order of removal of a content, then the intermediary has to remove the content within 36 hours. So these are the statutory timelines the intermediaries have to follow. And I believe this is the most significant achievement in terms of making internet not only safe, but accountable also. Can we have the next slide, please? So now I'm looking into certain scenarios. There is every possibility that you and I could put ourselves or be a part of a particular scenario. So I'm just putting across to you, and I believe there are things that may affect you. So what if? Can we have the next slide, please? Scenario 1, intermediary not having any grievance officer. If this is a problem that you are facing, what you should do? Send your grievance to any link available on the website or on that social media platform. Don't wait for that since there is no grievance officer, where should I have sent the link? No. Even if there's a contact us button, send your grievance. So this is a solution 1 to scenario 1. Can we have the next slide, please? Scenario 2, grievance officer refused to remove the offending content. This is a case, as a lawyer, I found it a very common practice. Grievance officer refused to remove the offending content. What shall be the solution? You can file an online appeal before the governing appellate committee. This governing appellate committee, the link that is on your screen is available. You can file your grievance against the grievance officer's non-removal of the offending content. And the grievance, this governing appellate committee will respond to you within 30 days. Can we have the next slide, please? Scenario 3, no remedial action taken by the said website or app and the offending content still exists. If despite the assurances given by the grievance officer that they have removed the content has again reappeared and the content is not going anywhere, please file an appeal. Filing an appeal against a grievance officer is your statutory right. And I believe each one of us has this right, and everything has been made online. Can we have the next slide, please? Scenario 4, the offending content reappears on the same website once again. It has been removed, but again it appeared, removed again it appeared. If there is a circumstances of this nature, again inform the concerned grievance officer or approach the GSE for redressal. That how come the same content is being made available again and again by the different set of individuals? And how come the intermediaries are not able to filter out such kind of content. It is their task to filter out and deploy technology tools to help the user. Can we have the next slide, please? The offending content is appearing on multiple websites, social media platforms. What should be done? The first approach is look for the grievance officer if their contact details are available on those sites. Approach them. If nothing is done, I think GAC is the most appropriate route for you to follow. So under any circumstances, I mean, these are the scenarios that I came across over a period of time. So I have tried to build a narrative here that if this happens, then what could be the possible solution available to you? Can we have the next slide, please? This is a basic do's and don'ts. Please make a note of it. If there's a content which you feel is harmful, hateful, obscene, it violates your bodily privacy, someone has impersonated you, someone has morphed your image, what you should do? 1. Note the URL of the web page or any link as available on the browser bar. Take a screenshot of the offending content. And thirdly, note down the date and time when you first came across such offending content. Taking a printout is also an important element here. Identify the email ID of the concerned grievance officer or any other contact information available on that particular website, platform, or any such app. At the time of filing grievance, identify the offending content. Now, this is important. Why you would like that this content should be removed? What is there in this content that is harmful, hateful, obscene? If there's a morphed image, then why you would like that these things have to be removed at the earliest? This particular issue of identification is extremely important for the grievance officer to provide you with a proper redressal. If it is not done, you have an opportunity in a form of an appeal before GAC. Don't wait for more than 15 days. Grievance officer, they have a window of 15 days. As soon as that window is closed, the grievance officer has not responded, please move to GAC for appeal. Now, appellate redressal. Can we have the next slide, please? Now, this takes me to a very important issue. And since I am addressing the resource persons from various universities and educational institutions, whether universities do fall under these rules, I think you have to look from a point of view of to self-test. Whether the university website hosted by you is an interactive website. Number 2, do you provide any micro-blogging interface primarily or solely enabling online interaction between 2 or more users and allows them to create, upload, share, modify or access information using university IT services? If you also provide a university email ID, and you have your own email servers. If you fall in this kind of, let us say, a kind of a checklist, then can we have the next slide, please? If it is yes, then the universities have to appoint the grievance officers under the IT rules. So the universities, I am of the opinion, as I have put across to you in the previous slide, if the universities are providing interactive websites, they are providing microblogging facilities, they are providing a dedicated university or institutional emails, then yes, they have to appoint a grievance officer. So it is going to be an administrative decision, but yes, you would fall under this kind of a category of being an intermediary. Can we have the next slide, please? So this is what I'm looking into. And as I have explained to you, the rules have created statutory obligations to provide an open, safe, and trusted and accountable internet for all stakeholders. So the issue is whether the internet is open, whether it is safe, whether it can be trusted, and whether you can make the intermediaries accountable. So it is for all stakeholders. And if I look into it more closely, then I am looking into a kind of an interplay of technology, transparency, and timeline as touchstone of digital regulations. This is what the basic premise is. The rules have brought in a kind of a transparency, and it has also provided a timeline. 24 hours to acknowledge the receipt, 15 days to go in for a redressal, 24 hours to remove the obscene content, 36 hours if there's a court order to remove the content. This is what I should say digital regulations are all about. It is important to flag here also, these rules do take into consideration the fundamental right to privacy and freedom of expression and speech. These rules have tried to create a kind of a balance between the user safety, the community safety, and the right to privacy and freedom of expression and speech. Can we have the next slide, please? So thank you very much. And I'm grateful once again that I have been given such an opportunity to address such esteemed gathering. Thank you very much.
Thank you, sir. Thank you very much. And please stay joined, sir. There may be some questions at the end of the lecture so that you can take it. And now we invite the next speaker, Madam Gauri Gokhleji. Madam, please.
Good afternoon to all, and my respects to all the professors out there. Thanks for this opportunity, and it's extremely important as such as Mr. Sharma and me, that whatever the laws have been framed for the benefit of us all should actually reach the right audience so that they actually get implemented. The example that Mr. Sharma gave, that we have a right to make complaint, we have a right to raise issues, and unless you are aware of the same, obviously the law will just remain on paper. So that is our duty as professionals to explain to you what rights do we have and how can we sort of take steps to avail of those rights. So all of us are aware, last almost maybe 5-6 years, and especially during the pandemic, most of us, at least those who have maybe in the metros and even in tier 2, tier 3 cities where there is good internet available, we all have been exposed to the online medium, especially for the online content such as Amazon Prime, Z5, Netflix, etc., Woot, and there are many more. We also have begun to consume news content online, right? So the question that arises, are there any laws really out there which regulate the manner in which this content is published, the nature of the content that gets published? And if we have any issues, what do we really do? You must, those who are sort of still watching television, you will remember that often you will find a scroll that comes below, that if you have any complaints vis-a-vis the content, please write to IBF, right? So basically there is a grievance redressal body, for any content grievance that we may have, we can actually write to the self-regulatory body that has been created by the television for the broadcasting industry, right? So I'm sure at least, I have availed of that right, and I have made complaints. So has my husband. I don't know how many of you have made the complaint, but we do have that right to make a complaint. Should we have any issue? Why do we why do we have that right in India, especially, right, to make such a complaint? Because though under Indian Constitution, we have a fundamental right of freedom of speech and expression, as we are aware under Article 19(1)(a) of the Constitution, that right is not absolute. Under the Constitution itself, under Article 19(2), it has been recognized laws can be framed to curtail such a freedom of speech and expression, but those have to be reasonable laws, right? Because we always talk about proportionality, and you would have seen that a lot of Supreme Court cases now talk about proportionality. So obviously the restrictions will have to be reasonable, but there are grounds that have been specified under the Constitution itself. For example, interest of sovereignty and integrity of India, public order, etc. Right? Obscenity, you're aware that there are laws against obscenity, so that would come, for example, under decency and morality. We often find cases that say that so and so filed a defamation suit against so and so, right? So that defamation is another ground itself, which can restrict our freedom of speech and expression. So when we have such laws, I'm not going to get into much of this, but I just wanted to show you by example that there are several laws, whether under Indian Penal Code, whether under Information Technology Act, Indecent Representation of Women's Act, Contempt of Courts Act, Representation of People's Act. This essentially talks about during the election, what nature of speech is permissible, what are the timelines within which such speech is permissible. Then there are several of these laws that exist, which curtail the freedom of speech and expression, right? And most of these laws have criminal sanctions. As in India, as we know, it takes a lot of time to sort of actually have the offender go through the trial and actually be sentenced, right? But in the meantime, the question arises, in the meantime, till such time the offender is put behind bars or penalized or whatever, does it mean, especially in the case of digital content, does it mean that the content can be continued to be made available, right? So that is the fundamental issue that the government was grappling with. And you heard Mr. Vakul Sharma that there are provisions vis-a-vis the intermediary platforms, which essentially talk about the content takedown, within 24 hours and whatnot, right? But the question really arose before the government that there are laws for the traditional mediums. For example, you have print media related laws. You have Cinematograph Act, under which, as you are aware, a pre-certification is required for theatrical release, for television release of a film, or video cassettes even, right? For all of them, a pre-certification is required. For the television content, there is no pre-certification, but there is a code of conduct that has been provided under the cable television network rules. And essentially, if, as I mentioned before, If you have a grievance, you can raise that grievance to the channel or the self-regulatory body to which the channel is a member, right? Now, the question arose for the digital platforms, what should be the way forward? There were several public interest litigation filed before several high courts to say that the content that our children are getting exposed to, or the Indian population is getting exposed to, is not kosher. It needs to be, there has to be some regulation around it. So the government in February 2021 amended the information technology rules that Mr. Vakul Sharma referred to, and actually now those rules in Part 3 also regulate the online platforms. So let me give a quick distinction that what Mr. Vakul Sharma said and what I'm saying. So when you talk about, say, a Facebook or Instagram or otherwise, the platform itself doesn't publish content, right? We are the ones who are putting the content on the platform. But when we talk about Z5 or a Woot or a or any news online news website, there the person who controls that platform itself is putting the content on the website. So they themselves are the publisher, right? So the question arose that when they are publishing such a content, what should be the way forward? Should there be a pre-certification, as in case of theatrical or or video cassettes films, or not? So the government decided that they looked at little broadly, and then they said that there is a slight difference between a pull and a push concept, right? When you say pull, that means when I'm going online, I'm myself deciding what to watch, right? So therefore, I am pulling the content to watch, right? But in a push, when you have a television, it is the broadcaster deciding what comes in front of you, in front of your eyes at that point in time on the screen, right? So that is the push content. So therefore, the government thought there could be some leniency provided when it is a full content, because the viewer itself or himself or herself is deciding whether or not to watch the content. But does that mean that there is absolutely no control? The answer is no. There are controls that have now been instituted under the IT rules. So they have categorized publishers of two categories essentially. One is the news and current affairs content, and the other one is non-news content, which is your typically entertainment content. Sometimes even documentaries would fall in this category, right? Any content which is not of news and current affair nature would fall in this category. They also realized that there are publishers who are operating from within India, and there are some publishers which are operating from outside India, right? So they said that if you're a publisher operating from outside India, you can't really control the world, right? So I will control only those publishers who are systematically providing their service to India. For example, they are acquiring Indian content, advertising in India by digital mediums. They are putting they are taking our currency is INR currency, they are taking the money, right? So basically they will identify that, okay, these are the people who are systematically providing their service in India. Then those also will be regulated in India, because as you know, we can't really regulate the entire internet, right? So this is the test that has been laid down. In addition to that, the intermediaries also, which Mr. Vakul Sharma mentioned, those intermediaries are also required to undertake a small compliance, that they need to inform, like that there are certain intermediary platforms where a publisher can actually run a channel, correct? So when you're running a channel on a third-party platform, even then that channel owner needs to go register with MIB. I will not use the word registration. It's at least information provision to MIB to say that, sir, I'm operating this platform on so-and-so intermediary channel. Intermediary platform, right? So therefore, it is extremely important for the intermediaries also to tell the news and current affairs platform that you please go register with MIB. Now, let us understand. I'm not going to spend too much time on the definitions, but this is just for you to have it, accessible to you as and when you want to view it. But if you really see, there are very important definitions which are online curated content. As I said, these are audio-visually content So it is not a print content will not come into this category. It is audio-visual content, but other than news and current affairs. And you will see that they are including films, audio-visual programs, documentaries, television programs, serials, podcast, any of that. When you say podcast, typically it means it's only audio, right? So there are several of these websites where you can just listen to the content and not really, have any visual aspect to it, right? Even that is included. Now let us see the news and current affairs content. So they have also defined, this is probably the first time the government has actually defined what is news and current affairs. So that also they have provided that there has to be a recency. If you see about recent events on social, political, economic, or cultural nature, etc. So all of that will fall in the news category, which is news and current affairs category. There is a reason that this distinction has been made, and I'll come in a bit as to why that distinction has been made. And of course, the publisher is very easy. That publisher is an entity which is publishing either a non-news content or a news content. But I want you, to draw your attention that you will wonder that, oh, if I'm, publishing, suppose I shoot a video of my family function and I put it on, on a, say, a Facebook or something, do I become a publisher, to comply with this law? The answer is no. Because if you really see the last, highlighted portion, it says, but does not include any individual or user who's not transmitting online curated content in the course of systematic business, professional, or commercial activity, right? But if you're conducting, suppose a university says conducting, online courses, right? And, there is some audio visual content, then, probably you may be doing a systematic activity. Of course, what I understand is that, the educational content is not really intended to be controlled by these laws. But, if you really see by the letter of the law, you may, get into the ambit of this, right? But if it is not in the course of regular business or systematic activity, then you are not part of that. Okay. Now let us talk about the publisher. We distinguish between the non-news and the news. So if you are a news publisher, right, then they'll have to comply with the journalistic norm. Obviously, you're aware that the Press Council of India has actually published the journalistic norms. So those norms will have to be complied with, and the program code under the cable television network rules will have to be complied with. So this is all content related regulation, right? What type of content can you really put out there? So these laws, give that guidance. So the first set of laws that we saw, where there is a complete prohibition, like obscene content, you cannot really, if you publish, then there is a penal consequence of that, right? But there is some other nature of content which may not fall in the offense category, but still you will have to, how you present, how do you have to deal with it? There is some guidance provided, in these regulations. And similarly, for the for the non-news content, they'll have to adhere to the code of ethics, and I'll come to that in a bit. And of course, they'll have to comply with the applicable laws of the country. Now, what does the code of ethics say? They require the publishers to, especially for the non-news content, they need to, do the age rating. That most of us will be aware, that even when we go to theaters, there is a rating, right? Adult content, 13 plus, etc. So similarly, for the online curated content, such categorization has been provided. Those of you who must be watching, the OTT platforms, you would have always seen, on the top hand corner, there is that rating given, 18 plus 30, adult, or, under 16. So when you say under stroke A, that means the person below, the 7 years, the 7+ years can watch that content. However, if the below 7 years, somebody has to watch that content, that it can be only by the parental guidance, right? So there are these, mechanisms provided. There is another important thing. So this is called age rating. So I'm just going to give you very, simple words for these categorizations. One is age rating. The other concept is age gating. That means that platforms have to ensure that there can be parental controls instituted if you're, going to put A+ content, right? So there are parental controls required. for you to have. And then there are other controls. If you're like 13 plus also, you need to put that control. Then the other important aspect, which there is a separate law also in relation to this, is the law also takes into cognizance disabled people, right? When there are disabled people, there is a indication given in the rules that there should be reasonable measures made so that even the disabled people have access to the content, right? So, for example, those who can't hear, they can see the bylines, right, that are provided below, right? Or there are something called closed captioning and things like that, right? So basically, you are making the content available to the disabled people to the extent technology allows you to do so. So there is an soft obligation that has been put on the OTT platforms as well. So these are some indications that I'm showing here. For example, it says A here, right? Or it says U stroke A 16 plus. So that means only 16 plus can watch it. If it is below 16, then it has to be under parental guidance. Then, of course, there is an access control mechanism, as I said. So this also you can put, the parent can put here to say that my child is, of so and so age. So I'm going to, whatever, when I'm giving access to my child to the platform, I'm going to control the manner in which I can, the child can watch the content, right? The content which will be access to my child. So those of you who are not doing that already, please ensure that your children are exposed only to the content, and ensure that even the parents of your students are aware of these these sort of mechanisms out there available, because this is mandatory under law. So all the platforms available in India will have this mechanism. Then of course the publishers have to inform the MIB about the fact that they exist. Then there is a grievance redressal mechanism. I'm not going to spend time on the other compliances that you can refer to later. For example, the publisher has to give periodic compliance to MIB. They have to keep records of the shows that they have telecasted, because as an evidence, etc. But what I'm going to do is give you more indication as to the grievance redressal mechanism, because that is where our role comes in. Should we have any objection vis-a-vis the content? Now, if you really see that it says the publisher has to establish a grievance redressal mechanism. That means they need to have a grievance officer, same as intermediaries. They have to have a grievance officer, and the information of that grievance officer has to be made available on the platform of the publisher. Now, suppose I have a issue. There is a 3-tiered mechanism that has been created. So my grievance first I will take to the publisher. If I'm not satisfied or the publisher doesn't respond, then I can go to something that has been established as self-regulatory body. So these self-regulatory bodies have been established, they have been registered. You can go to MIB's website. This is the Ministry of Information and Broadcasting website. Their names are published there as to who are the self-regulatory bodies. So suppose, just to give an example, say I go to, say have a complaint vis-a-vis a particular platform, and I'm not satisfied with the response, I can go to the self-regulatory body of who that platform is a member. Now, if I'm not even satisfied with that self-regulatory body's response, I'm not remediless. I can go to the oversight mechanism established by the MIB, and I will explain you what that mechanism is. So who are the stakeholders here? You have a user, that is you, publisher, whose content you're watching, self-regulatory body, and an interdepartmental committee, which has already been set up by the Ministry of Information and Broadcasting. So who is supposed to be the part of self-regulatory body, and what can the self-regulatory body really do? So you will notice that the government has been very thoughtful, and they have said that either a retired judge of the Supreme Court or High Court, or an independent, eminent person from the field of media broadcasting. So they have also recognized that there will be other experts who will be required as a part of this self-regulatory mechanism. So suppose you say that, just to give an example, that certain content that you're watching, and you say that they have written it is a open content, right? It is you content, right? That means anybody can watch it, but there is certain content within that show which should not be watched by people or kids below 13 at all. if that is what you believe, right, you can actually raise that issue. If you believe that certain content is obscene, you can raise that issue. If you believe certain content is, creating issues, insofar as religious issues and things like that, because that also is a part of the code, that you will not create content which will create enmity between two religious sections of the society, right? If you feel any of that is being violated, and I would recommend that, and it's a very simply written document, I would recommend that you see the code of ethics, so you will realize how the government has thought through, about the nature of the content. For example, if there is nudity, sex, even, you abuse of drug, all of that has to be taken into account. And in line of the content, they have to do the age rating. They have to put disclaimers. They have to put guidance. You would have also seen sometimes they say, abusive language, or they say that, content may carry violence, right? So those things, if you feel that they have not given enough warning, right, then you can raise such a complaint to the publisher. Now let us see what the role of the SRB is. Basically, they have to ensure that their members are adhering to the code of ethics. They have to, address the grievances. They can even, from time to time, issue advisories to the platforms. For example, if they notice that certain type of content is coming again and again, and the audience is raising an issue, they can issue an advisory that you should avoid this kind of a content, right? So that kind of, proactive role they are expected to play. Now, the Ministry of Information and Broadcasting also has an important role to play, because they can from time to time publish, charters. Now, for example, the Code of Ethics, which I referred to, has been published by MIB, and they can, update that or improve that code from time to time. They also have to, give guidance to publishers from time to time, etc. But the most important part is they have to set up this interdepartmental committee. Now, this interdepartmental committee, as I said, is the third tier where ultimately your complaint will go. Now, this particular mechanism, this machinery has representations, as you can see, from all these departments. So, for example, sometimes the content is of a nature where, it may affect the sovereignty of the country, right? So, obviously, Ministry of, External Affairs or Home Affairs, these are the relevant departments which will have a say about a particular nature of content, right? Sometimes, there is a child abuse shown or otherwise, then of course the Ministry of Women and Child, will come into play, right? So therefore you need, representation of these departments or ministries, and that is how that body has been formed. Now, let us see quickly the grievance redressal mechanism. So you can make a complaint, as I said, if the content is violative of law, there is no, proper description given, the age rating is not appropriate, whatever. So you will make that complaint to the grievance redressal officer, who has to acknowledge it is in 24 hours, and they have to resolve your complaint. When I say resolve, does not mean they necessarily have to agree with you, but they need to give you a reasoned order, say in 15 days time. If you don't hear back from them, you can directly go to the SRB, which is the self-regulatory body, to say that I have not heard back, from the publisher at all. Or if you're not satisfied with the publisher's response, you go to the SRB. Then SRB also has been given specific timelines within which they have to respond. If you're not satisfied, again, you will go to the oversight mechanism. Sometimes the ministry itself may notice certain content and refer that content to be evaluated. Either they may write to the platform that they have all the right to do so. They may even directly ask SRB to look into it, or they can even directly tell the this particular committee to look into the issues, and then the committee itself doesn't issue orders. The committee makes a recommendation to the secretary of MIB, and ultimately it is a secretary of MIB which will endorse the decision, and that decision then becomes final vis-a-vis this process is concerned. But of course, if somebody is not satisfied with that decision, a writ remedy, as you are aware, in India, we have a writ remedy before the High Court or a Supreme Court, right? If your fundamental right is violated, right? So in that context, or if you're not satisfied, with the manner in which the process has been undertaken, then also you may, approach a writ court to say that, the process has not been followed under law, and then the writ court may direct them to follow the process established under law, right? So this is really a mechanism. I'm not sure whether the children or their parents are really aware of this, but you do have this right, as I said. One important aspect also is what are the nature of the orders that can be given, right? So of course the platform can be warned, they can be required to make a warning or a disclaimer to the content, or rectify the age rating. So all these things the self-regulatory body can order the platform, right? What the self-regulatory body cannot do is they cannot ask the platform to delete or rectify the content. That right they don't have. They can only refer it in that case to the ministry's body, and in that body they will take a decision whether or not such a order should be granted, right? So for example, the committee can grant these orders, and they can even recommend. Again, as I said, the committee itself cannot ask for deletion, etc., but they can make a recommendation to the secretary MIB to say that this content should be deleted, or this content should be modified, or etc., and then the secretary will issue that order. Now there are situations sometimes where we feel that we can't, the content of such a horrific nature. And when I say horrific, it is not like obscene content, etc., will not fall in this category. The category that will fall under is the let me just go back. Sorry. Anyway, so the category will be the original side which I showed you, where it is sovereignty and integrity of India, or it is a public order issue, right? In those type of cases only, the MIB committee may decide to take an emergency measure to to ask the platform to take down the content, and thereafter examine the content in more detail to say whether or not such a content should be continued to be taken down, or it can be allowed to be uploaded again, but with certain modifications or otherwise. So that is all from me. But the takeaway for all of us is that we should definitely look at the terms and conditions of the website, identify who the grievance officer is, keep the contact details handy, ensure that if you are not happy with certain content, before that, if you have children, or tell your if you have children, you should put up the age gating out there on the platforms that your child may be accessing. Educate the parents of your schools and universities or otherwise of this particular facility. And if you have a complaint, do exercise the right that is made available to all of us on the platform to make a complaint, and ensure that you carry that complaint to the MIB level should you not be happy with the responses that you have received at the lower level. So with that, I hand it back to the organizer.
Thank you, madam. Now it's open for any questions. If anybody has any question, please raise your hands electronically. Any questions? From our viewers also, there are no questions, madam. So some viewers have asked for whether these PPTs can be shared or not. So
sure. I will mail it. You can freely share it. Not a problem.
But in any way, these lectures are available in our the social media channels, and anytime they can watch their convenience. There is one question. Dr. Madhukarji.
Good afternoon. Thank you, Sharma sir and Gokhale madam, for very nice information and very important information. My question to Sharma sir. Sir, recently there are directives from the MIT to appoint the Chief Information Security Officer. And today also we discussed that grievance officer should be there. So can any organization consider CISO as a grievance officer also?
Okay, sir, when I'm looking into a grievance officer, then
Yeah.
grievance officer is from the point of view of grievance redressal. But when I'm looking into a chief information security officer,
Yes.
that chief information security officer is having a different role to perform. So you cannot ask the same person to perform a twin role. So ideally, it is better to have a grievance officer and a CISO as
Yeah.
a different person,
Okay, sir.
right? But
Thank you, sir.
my request to you is that the kind of pointers that I have put across on the slide, if your educational institution or a university is checking on those boxes of providing intermediary services, then it is imperative that you should have a grievance officer to look into any such grievances coming to you.
Okay, sir. Thank you, sir.
Thanks very much.
The Vice Chairman UGC is also with us. Sir, you would like to share any thoughts, sir?
Yes, yes. No, but this, please allow me to unmute. Yes. I think both the discourses or lectures are very relevant. Now, today, the youth, which is born in the new generation, must know that how to use, as our chairman has rightly mentioned, that the social media or the ICT platform should be used in a positive manner rather than negative manner. And government and honorable courts have been trying their level best to provide a very safe uses of information and communication technology. So I think both of these lectures, this Chetna series lectures, were thought-provoking, and I have been receiving very good feedback from our viewers, those who are attending this. So it's very nice to have both of you today, and I think our viewers and we have been enlightened. Maybe in due course of time, as technology changes, because today I'm also thinking I'm HR background, people-centric. So I'm always concerned about the uses of artificial intelligence and so on and so forth. That's very challenging for this generation. So I wish that with the directives given by Honorable Court from time to time, and with very, very learned counsels like Vakulji and Gokhale Madam, I think things would be on right track. So we look forward to your other contributions at some other point of time. We'll invite you again if there are any updates in your area. On behalf of UGC, we thank you very much for being with us for 1 hour, giving a very, very, today we made you professors. So because both of you have very well, your PowerPoint presentations are very nicely prepared, which normally it is not a court language because judicial language is entirely different. But sir, you have made a good justice, and madam also, you have made a good justice. And these your discussions would be available on our social media platform. Thank you very much to both of you.
Thank you very much.
Thank you for the opportunity.
Thanks, sir. Namaskar.